The defendant was indicted, count 1, felonious assault, a felony of the 2nd degree with a firearm specification, a 1.5 year and a 4.5 year firearm specification, and also a repeat violent offender specification, and also a forfeiture specification for a Taurus revolver and a Ruger 9mm pistol. Count 2, having weapons while under disability, felony 3, which with the same 2 firearm specifications and the same forfeiture specification. Count 3, having weapons while under disability, felony 3, with the same firearm and forfeiture specifications. Count 4, inducing panic, felony 4, with the same 2 firearm specifications and the same forfeiture specification. The defendant was evaluated for competency, and he was before the court on July 25th, 2022. He, at that time, court learned that the defendant fired his attorney 2 times on that day. He wanted him back. And then counsel decided that he no longer wanted to represent the defendant because of deep distrust. I appointed a public defender to represent the defendant, and I set it for a competency hearing and arraignment in about 2 to 3 weeks. The court had 2 opinions that the defendant was competent, both by the court's forensic psychologist, Dr. Rinsberg, and North Coast Behavioral Health Care. The defendant was before the court on August 22nd for arraignment. A not guilty was entered and bond was set. The matter is before the court for pretrial. Ms. Alessi, would you explain to me what the state contends occurred here?
Yes, Your Honor. The defendant was at United States in Wickliffe at a child's birthday party. Upon exiting United States, he had some verbal altercation with another male that was on scene. While the defendant went to his vehicle, pulled the vehicle around to the front of United States, and continued to have this verbal altercation with another male. The defendant then began shooting at the other male. He fired 5 rounds from the Ruger 9mm and 3 rounds from the .38 Special. The defendant then ran from the scene. He ran into another building, instructed that they called police, and then continued to run off scene up onto Euclid Ave, where police then apprehended him. Upon Mirandizing and questioning the defendant, he admitted to shooting the firearms, to having 2 firearms, and to also shooting first on that day.
And does the state have an offer?
Yes, Your Honor. And I should add, by way of the facts, United States, as a result of the shooting, did have to close down for the remainder of the day. While the shooting was occurring, all of the people inside, including numerous children, were kind of sequestered to the center of the dance floor, and then they ended up canceling the rest of their birthday parties that afternoon, which is why there's an inducing panic as well, and that the defendant was on parole at the time of the offense and under disability for numerous offenses as well. And for a offer of a plea agreement, the state made the following offer to defense counsel: to plead to felonious assault, a felony of the 2nd degree, with the attached 54-month specification, and having weapons while under disability, a felony of the 3rd degree with the attached forfeiture specification. if resolved by way of plea agreement with a joint sentencing recommendation, the state agreed to recommend 12 and a half years in prison. Applying Reagan-Tobes, there'd be an additional indefinite prison term of 1 to 4 years. And if the defendant did not wish to join in the state's sentencing recommendation, the defendant could request any available sentence, and in that case, the state would recommend a sentence greater than 12 and a half years, and it would also be the state's position that those counts, the felonious assault and having weapons under disability, would not merge for purposes of sentencing.
So your offer is to count 1 and count 2?
Yes, Your Honor. With just the 154-month specification on count 1.
And the forfeiture specification on count 2, is that what?
Yes, Your Honor.
The case is set for a jury trial on November 1st. The impediments to going forward on November 1st?
Not from the state side, Your Honor, no.
Defense?
Not from the defense's side either, Your Honor. We are aware of a motion that the defendant filed pro se on September 16th, asking that the public defender's office be withdrawn. If we're able to address that today, and if we do remain on the case, we would be prepared to proceed on the scheduled trial date with Mr. Wynn.
Okay. Well, let's address that today. Mr. Wynn, you are asking that, is there any attorney that would ever satisfy you in this case?
Yes, I don't want to, I stand up.
You don't have to stand up.
Yeah, I don't want to fire her. I just want her to file a motion because, like, when I got caught, I did not. Okay, look, I just want her to file a motion for criminal rule 29. For the acquittal of count 1 of felonious assault due to insufficient evidence. Because, Your Honor, when I got caught, Your Honor, I never said that I shot first. My exact words.
Well, hold on. Anything you say can be used against you.
I know, Your Honor.
Okay, so don't say anything. Let me just tell you that a Rule 29 motion is made at trial. Okay. I have to see the evidence, because just because the prosecutor said this is what she believes the evidence will be, doesn't mean that that's what the evidence will be.
Okay.
So I have to see the evidence, how it plays out, and consider a Rule 29 motion at the time. Okay. And it would be after the state rests.
Okay, yeah.
Or after they make an opening statement, if they
I didn't want to fight her. I just wanted her to file a motion, and I wanted to file a motion to suppress all the evidence that they have. In my statements from talking to the police, I was incompetent in my statements when I was talking to the police, so I ain't know. So I want her to file a motion to suppress my statements when I was talking to the police, and a request for acquittal of the count 1 to the indictment due to insufficient evidence, felonious assault due to insufficient evidence.
Okay. I hesitate to ask this. How is he incompetent? Did the police make you incompetent?
You said what?
Did the police make you incompetent?
No, when I got caught, my lawyer right here filed a motion for the incompetency, and then that's why I never got charged, because I was in here for 8 months due to I was waiting on the evaluation, labeled incompetent, waiting on the evaluation. That's why I was in here for this moment. My case would have been over with. They labeled me incompetent, even though I kept.
Who labeled you incompetent?
You did, and when I was, and they.
Your Honor, I believe when Mr. Wynn came before the court with Mr. Shorn, at one point in time, I think based on Dr. Winsberg's report, they were prepared to stipulate to that report some of Mr. Wynn's behavior, I think, concerned the court. And so the court asked that a second opinion be made from the post. And so
okay, I didn't declare him incompetent or labeled him incompetent. I wanted him reviewed for competency.
Yeah, but that's when my paper said I was incompetent. So
what paper said you were incompetent?
I got a paper saying I was waiting to go to North Coast to be evaluated. So that means,
to be evaluated.
Yeah, but I don't. But like often record. I just wanted to.
No, nothing's off the record here. It's
not
all
off
being
record.
recorded.
I just wanted to file these motions due to insufficient evidence. They have no victims or any witnesses, and I have witness on my behalf.
Well, I understand. I understand your statement about victims.
I'm the victim in this.
Hold on. I understand what you mean by a victimless crime. Nobody was hit, right?
Yeah.
Okay, but
I'm the victim.
And you'll have an opportunity to present your side of the case. But first things first. I never labeled you incompetent. When I label somebody incompetent, that means I declare them incompetent and I order them restored to competency based upon a particular treatment plan to do that. It never got to that point because both reports that I have from the professionals in two different institutions said that you were competent, and I agreed with them that you were competent, and I declared you to be competent to stand trial.
Your Honor, if I could I present the judgment entry to the court that Mr. Wynn has been?
Yeah, let me see it.
Thank you.
And if I may, the court did find the defendant incompetent in that JE dated April 5th, 2022, and ordered the defendant be sent to North Coast to be restored.
Oh,
And at that point, I think, I don't know if it was due to bed availability or whatever the reason was, North Coast ended up sending a doctor here to evaluate Mr. Wynn instead of him going to North Coast.
okay.
At which time they rendered an opinion that he was competent as well. We had another hearing,
That's
defense
what
and I stipulated to the contents of that report.
I have it. So they didn't have to restore him?
North Coast found him competent, and so that there was no need for any restoration.
Okay.
He never left our facility.
All right. Was this done at the time that he fired his lawyer twice? That same hearing?
No, I think this was back in April, Your Honor, but after Dr. Rinsberg's opinion was rendered.
Okay.
Then the court ordered that North Coast do the evaluation, so some time period passed until, I think, July.
And North Coast, I wanted it done here in order North Coast
that he be sent to North Coast, and I don't, for whatever reason, I don't know if North Coast didn't have bed availability.
Okay, so they wanted to send the doctor here.
Yeah, so the doctor came here to evaluate.
Okay.
Yeah, it was not your direction that North Coast.
All right, it's coming back to me now. All right, so the defenses that you're talking about can be raised at the trial, and the trial is set for November 1st. You're ready for trial on November 1st?
Yes, Your Honor.
Okay. So barring any unforeseen circumstances, that's what it'll be. And so does the defense specifically reject the state's offer?
Yeah, yes, I reject.
Okay, anything further?
No, Your Honor, thank you.
There was just one other thing that I wanted to address from the defendant's motion to ask the public defender's office be withdrawn. He stated that he didn't have discovery. I just want the court to be aware that that has been fully provided to him, and we've been able to go over it.
Okay, you agree, you got the discovery, correct?
Yeah.
Okay,
Thank you, Your Honor.
all right, we're adjourned.